Good afternoon, or I guess good morning or good evening, depending on where you are. It's Monday, it's July 22nd. There is a hearing today in the Karen Read case, Commonwealth versus Karen Read. For those of you that have been following along, there's a lot going on in this case, but today's hearing is supposed to be a trial setting conference, which means they would set the date for the retrial. The prosecution will formally state that they are retrying the case on the record. That is what today is for. And then they'll set hearings and they'll set a timeline. That's what's supposed to happen. But then the defense filed all those motions, and we're going to take a few minutes to go over the defense motions that were filed. So we'll go over all of those defense motions, and then we will get into, well, we're going to do a quick summary, and we'll get to live court when court starts. Court is scheduled to start in about 10 minutes from now. I don't know if they will be on time. Look, Alan Jackson is supposed to be coming in remotely. He said he had another conference when they set this. That was all done well before any of the jurors came forward, before any of this stuff popped off. So we are going to see what happens. Do I expect the judge to rule today on the defense motions? No, I don't. No, I don't. Do I expect we will get much resolution today? No. Do I think everyone's going to make a record? Yes. Do I think that's about all that we're going to get to? Yes. That's about all that we're going to get to. So with that, we're going to get to court when they start, and we will see what happens. Again, supposed to be a scheduling conference, but the defense motion briefing is done. So we're going to do a quick summary on those because the briefing is done, which means the court can address it. Will they? I mean, the defense is going to demand to be heard on it. I think they should be heard on it. And here's the thing. You can't go forward on a scheduling hearing without dealing with these outstanding motions. You just can't. So it has to be addressed. There's no other way to get around it. So let's roll the intro. Let's let everybody come in. Hey, everybody. Good to see you. Law Nerds, you're the best. I've got greens this afternoon because I didn't do that this morning. So balance. Y'all, look, I know if I'm accountable, if I'm on screen, I will actually do it. So we're going to do that. But court's set to start in about 10 minutes. Will it start in 10 minutes? I don't know. But before we get rolling for court, don't forget to do the YouTube things, like the stream or the VOD, subscribe to the channel, all the YouTube things that lets YouTube know that, you know, we're the #1 place to watch live trial coverage, because it's true. Law Nerds, it's good to see you. We're going to roll the intro and we're going to get going. It's a court day on a Monday. Because when there's court days, there's court days. I should remind you that if you want to stay in the loop, we are doing lots of improvements to the Law Nerd app. The world of technology in the universe timeline that we're living in right now is spicy, especially if any of you have tried to like travel, go to the bank. It's spicy, but we are working through what we can do to make sure that you get your app notifications on time. And when the entire internet gets spicy, well, it's a good reminder for me to be patient, because it is an attribute that I absolutely struggle with. Do we struggle with being patient? Yes. Do I want the court to rule on this today? Yes. Do I want to know everything that's going to happen? Yes. But we're going to breathe and do our best to be patient and let things unfold as they should. Is it spicy? Yep, it sure is. So let's roll the thing that hasn't been spicy, the intro. We had to de-spice it a little for the cursey words rules, but you know, it is what it is. So let us roll, and then we're going to get to court.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the Law Nerds unite to talk about facts, not. Let's get into it.
Speaking of spicy, the court feeds are already being spicy, which is a joy of joy. So we're going to wait for that to come back as they are trying to figure out, it looks like they're trying to figure out their encoder. So I'm going to pull a backup stream real quick. And then we are going to pull that up. I'm going to do a summary, but I can't do it while I'm also pulling a backup stream. So I know there's a lot of things I can multitask. There really are, but but there's only so much I can do depending on the thing. So we had a moment that they were in court, and then that moment passed. So let's make sure. Well, you know, we're reliant on the technology of others, and if anything in the world has been spicy, it's technology. Isn't it? So let's all cross our fingers and hope that the technology plays nicely with us. Let's do a quick summary of these motions. It's good to see you guys, but first let's take a moment to thank our incredible gifters. B2, thank you so much for the gifted memberships. I absolutely appreciate it. Shazam, thank you so much for the gifted memberships. For all of the new members, welcome and thank you. Kristina, thank you for the gifted memberships. I know it is the dyed in the wool, tried and true law nerds that are rolling for like the non-trial court hearings. It's fantastic. Wendy, darling, thank you for the gifted memberships. We're going to get to a few questions as hopefully this court feed gets rolling. There we go. We might have court. Why is it not playing well? I don't know. Are we optimistic that it will? Sure we are. We'll maintain a sense of optimism. So let's do a quick summary of where we're at while, you know, court is not yet on the record, but going. So for all of you who's just tuning in from the trial, pop a 1 in the chat if you're just tuning in from the trial, and if not, followed along with all of the post-trial litigation, because man, it's been a lot. So this case ended. Ooh, we're starting to get a little bit of audio. Not actual audio, but a little bit of like echoey audio. All right. For those of you that watched this case end in a mistrial after the jury had deliberated for days, after 9 weeks of testimony, 75 witnesses, and all the rest of it, this case ended in a mistrial. The jury said that they were unable to decide, and they came in on their third note. They had been given the stronger instruction that said, remember, try to come together. No one is better qualified than you to come to a verdict. So try your best. Go back and do it again. The jury had a very thorough note that said no amount of further deliberation will break the deeply held convictions we have in the real and held disagreements that were existing with the jury. So the court said, I'm not going to make you do that. I'm declaring a mistrial. Bye. And everybody was like, okay. So the court did not ask anyone anything. Oftentimes the court will ask the jury foreperson, you know, where are you split? Are you divided on count 1? What is the vote split? Are you divided on count 2? What is the vote split? Are you divided on count 3? What is the vote split? That did not happen in this case. None of the attorneys asked for it. But then days after the mistrial, and again, as they left court that day, they scheduled this hearing. There were no objections put on the record. It's not a fan, it's a light. Just leave it. Just leave the feed. There were no objections put on the record. There were no issues put on the record. It was very much okay, here's the next scheduling date. And that's what they did. They set a scheduling date for today. After that, the defense filed a motion asking for a dismissal on count 1 and 3, stating that the jurors had in fact come to verdicts. And let's see, that's not coming through where it's supposed to be. Give me 1 second and let me try to make sure this is coming through where it needs to be coming through. Oh, Emily, did you mute it by accident? Yeah. I have no audio at all. Give me 1 second because there we go.
Translate into which language?
Cancel.
appearing on behalf.
My S-word device started talking immediately. So they are back in their courtroom that they weren't in for trial. The jurors that came forward, 3 came forward directly to Alan Jackson. 2, it was heard it by a game of telephone. The defense says counts 1 and 3 need to get dismissed. The Commonwealth said, no way, we're retrying this on everything. We're going to hear the Commonwealth today say that they are retrying this case. And there is a new member of the defense team that is not a replacement for AJ, but he was appearing via Zoom today. We'll see if we see him on it. So we are going directly to court. So, law nerds of the virtual jury, we are back in court for hearings. So there is no bring the jury because there is no jury to be brought. we are not bringing a jury, but we are bringing you to live court. Let's roll. No, that was not dramatic at all. Ugh, Emily. Streaming is dynamic. We'll fix it in post. Let's go.
Good afternoon, Your Honor. Martin Weinberg, appearing on behalf of Karen Reed.
Good afternoon, Mr. Weinberg. It's nice to see you.
Good afternoon, Your Honor. David Giannetti for Karen Reed.
Good afternoon, Mr. Giannetti. Good afternoon, Ms. Reed. All right, so the case is scheduled today for trial assignment, and what I'd like to do is to get 3 dates. I'm aware that a motion to dismiss has been filed. I'd like to get a quick date on that, and I'm glad you're here, Mr. Weinberg, because I'd like it to be with your schedule. Then we
They're
need
setting a
trial
date for that motion.
And we need a final trial conference. So I was thinking on the motion to dismiss, can we do it a week from Friday? It would be for oral argument only.
From the defendant's perspective, yes, Your Honor.
All right, I think that's August 2nd,
I
Mr.
apologize,
Clerk.
Judge Kristina.
I'm going to be out of state. I return on August 3rd.
I can't make court any louder. Sorry, y'all.
Okay.
They're trying to pick a date for that motion to dismiss. I can't make court any louder. It is as gained up as gained up.
August 9th? Are you available? 2 o'clock. Are you available, Mr. Weinberg, on August 9th? Mr. Lally, is the Commonwealth available on August 9th?
Yes, Your Honor.
All right, so that's for oral argument only.
That's for the motion to dismiss for oral argument only. The judge is not going to rule that
2
day.
p.m. All right.
Oh, she's just kicking that right out.
Given the schedule, and I assume whatever I end up doing on the motion to dismiss will be appealed. In an effort to make sure we have plenty of time, I would like to schedule the jury trial on January 27th.
Wow.
Is the Commonwealth available?
That's fine, Your Honor.
Mr. Nettie?
That should be fine.
Okay, so January 27th for trial. And let's do the final trial conference the week of the 13th or even the week of the 6th.
She's not straying from the trial setting of it all, is she?
Yeah, there's nothing, just not the 9th or the 16th, but all the days are open.
Okay.
Your Honor, the only caveat, I don't have anything on the 27th. I'm clear for that day, but for the fact that I have a Superior Court trial scheduled to begin in Essex County on January 13th. There are multiple...
How long do you expect it to take?
That's what I was getting to. That could take longer than 2 weeks. I'm happy to have this case take priority over that, but that's...
No, we'll hold it for you day to day if need be, and I can contact the Essex Superior Court judge once you know who he or she is.
Yeah, that's not ideal. In terms of preparing for trial, I can't do 2 or 3 week Superior Court trial and then jump into this case. I can't do that.
Okay? So what are you telling me? You just said you're willing to make this a priority, so we'll stick with the 27th?
Well, okay. Well, why don't we do this? Let's put it on for the 27th. Let me see if I can make peace in Essex County. And then on the next date when we come back for oral argument, if I can readdress the court on that issue.
Okay, I'm happy to talk to Judge McCarthy, who's the barrage up there, about this.
It's yeah, okay, that's great.
All right, so let's set it for the 27th. And Why don't we do the 14th for final trial conference?
The 14th at 9 or 2?
2. If it turns out that we have, in excess of 35, or whatever motions and eliminates still at
Yeah,
that
you will.
point, let us know, and we will try and get the whole day. Okay?
That's going to be it.
Thank you very much.
And that's going to be it.
Thank you, Your Honor.
All eyes to the board, please.
8, 9, and 2 p.m.
The way the court was just like, and we're done. That's all. The court said scheduling conference. That's a scheduling conference. Don't worry, we're gonna chat about it. But that's it. That's the scheduling conference, and now we've been scheduled. So yes, that's what they all came in for. Let's gain this down a little bit. This is what a lot of court hearings look like, y'all. This is what a lot of court dates look like. We're going to turn that down just a little. But that's it. That is what most, hold on. That is what most live court hearings look like. Let's take a peek. Another feed still has court up, so we're gonna put that up real quick because why? Because we can. Why not? So we're gonna switch feeds real quick as everybody empties out of the courtroom. But that's really it. Oh, let me do that a different way. That's really it. So and then we'll get to questions. But that is what most hearings look like when they say scheduling conferences. Don't worry, we have lots of time for questions today. So don't worry about that. And we will get to questions. So let's see, as everybody files out of the courtroom, kind of who's talking to who. Not much of who's talking to who as Karen Reed files out of the courtroom. Her family's right there. She's talking to her dad, and that's about it. So that's everybody filing out of court. I'm going to go ahead and mute the background noise, but that's everybody filing out of court. And that's it. So that is the entire scheduling conference. I see AR saying, why wasn't this an email? You have to bring all of the the attorneys in, the defendant in, and then you have to set dates on everybody's calendar. And that is much easier to do face to face. Have you ever tried to set dates with 5 to 7 people with really complicated schedules without being in a room together? It's impossible. It's impossible. But quite a lot of court hearings look exactly like that. All right, nothing else went down in court. I zoomed to the end of that hearing, and we're going to get to Q&A. Yay! Let's go ahead. All right, everybody. So, blink and you missed the setting conference in the Karen Reed case. It was exactly what it purported to be. It was a trial setting conference. The court set dates for the motion to dismiss to be heard. We're going to talk about that. So the court set dates for the motion to dismiss. The court set dates for the trial. The court set the trial for January 27th and the final trial conference for January 14th of 2025. So generally, without objection, the court should go to within a year of when it got dismissed. So that is the trial setting conference. For all of you that are like, that's it, that's it, that's all. That's exactly all. That's exactly all. So why can't these be over Zoom? The court asked everybody to come in, and they want the defendant to come in. It is a case where the defendant should be present in court for each hearing because it is a murder case. So with all of that, that's the setting. I like your dog more said, so disappointing. I hope not. It's a scheduling conference. Was the court going to address the motion to dismiss when she hadn't set time for the motion to dismiss? Probably not. Did I think the defense would try to argue just a little? Yeah, I did. But we've seen how unfriendly the judge is to that when they try to bring things up. And the judge immediately said, we are going to set the date for that. And the court absolutely set the date for that. So we will be back here together. I'm going to keep answering questions, but we will be back here together on August 9th, 2024 for that oral argument on the motion to dismiss. So let's do a quick summary for everybody just popping in. Let's do a quick summary of what happened, right? For everyone just popping into the scheduling conference, it lasted, what, 5 minutes? That's very typical for a scheduling conference. The court took the bench and said, these are the dates we need to set. First, we need to set a date on the motion to dismiss. I have the motion. We are setting a date for oral argument, meaning that the date is set for the attorneys to come in and argue their motion, to explain anything that the court wants explained, and to argue beyond what's just in their filings. That date has been set for August 9th, 2024. We will be back in court together on that date. The court also set a trial date for Karen Reed on January 27th, 2025 to start that trial. A final trial conference setting on January 14th, and the court said, and if we have a ton of motions, we will set that for the entire day. So the court did say, I anticipate whatever I do on the motion to dismiss, there will probably be an appeal. So the court is giving enough time for that process to happen because the court is saying, whatever I do, someone's going to want to appeal it. So why don't we just set the trial date out far enough to accommodate that potential for appeal? And that's really it. So we have dates set, future dates set in the Karen Reed case. This is typical of most court dates. So when you go to court on scheduling conferences, oftentimes on cases that are not homicides, you can do those by teleconference. You can do those by not appearing in court. In criminal court, it's very common that you appear in court. If the court has questions, it's common. And I'm not surprised the attorneys wanted to be face-to-face with the judge, given the motions that they had, just in case the judge was trying to push out the argument on that motion. And the court didn't do it at all. The court said it was very conscientious of getting that date set very quickly. And so there was nothing for the defense to argue about. Hey, we're going to get this set very quickly. Here's where it's going to get set. So that's what the court is asked to do. And with that, we will get into Q&A, shall we? We shall. We should just get to questions. And if you go to live chat, you will see that there is a questions tab. If you want to ask questions there, I see quite a lot of them in the questions tab, but I am only going to ask questions on this case. So if there are questions there, I will be answering them on this as well. So it's in that live chat tab. And of course, answering your super chats and member chats. Why? Because we have time. And, you know, if any of you come in late and we want to replay the hearing, maybe we'll consider doing that too, if need be. If need be, we can consider replaying the hearing. It took all of 5 minutes. So if it's needed to be, I will put that up. I will put that up for you. So just a reminder, because it seems that we have some new folks in the chat that maybe aren't used to our chat. We do not really give opinions on guilt or innocence. We are here to watch what a jury decides. We are not the jury. We are the observers. We are trying to watch what the court is going to do. But I'll put up a poll in a little bit. I'm going to answer some questions real quick before we do that. And then we'll get there because, well, you know what? We've got a minute, don't we? We've got some time. Look, this hearing could go very fast or not very fast. And do you know what it did? It went very fast. Are we mad about it? No, not really. Am I mad? No, that is a very controlled and a very typical court hearing. So let us get to your questions. Did I go to Q&A yet? No, I didn't. I totally forgot. Let's do it. Kelly's Crochet Palace said, so thankful for you, Emily. Love being a law nerd. I love having you guys here. I love this community. So thank you, Kelly, and everyone. It's good to see you guys. Amanda said, wearing my Facts Not Fuckery hat this fine Monday. Me too. I am immediately wearing my Facts hat, and on the back it says Not Fuckery in all black, which means some people know it's there and some people don't. Laura said, EDB, did you see some of the Baldwin jurors spoke? I haven't seen that yet, and maybe we'll go look at that for tomorrow, because I think with this hearing being short, tomorrow's going to have to be short if we stream tomorrow so we can get the podcast done, but we've got time. Larugio asked, is it a new judge? No, it's not a new judge. This judge is staying on. I think there was some confusion because of the way Massachusetts does their docketing. The judges do rotate between criminal dockets and civil dockets, but this judge is staying on this case unless this judge states that they are leaving the case. But it will get docketed. It got docketed oddly because of the way the judges rotate in the docketing. So that's what that is. Kimberly celebrated her 52nd birthday this weekend. Happy birthday, Kimberly. I hope it was amazing. Katie said, Law Nerd app notification sound is the same note as my doorbell, which causes my dogs to run to the door every single time it rings. Even now on vacation, they went barking to the door every time. I don't know if you can change the tone in your apps. I don't know if you can or not. It'd be interesting if you could. Here for court. Love DMB 41 and 36. 2 different songs. Not everybody would know that. Love the profile pic of the Dave. Here we go. Yeah, well, here we go. Here we went is what happened today. Sarah said, who had Y2K on their bingo card this week? For real though. Like, so for real. The internet is definitely giving Y2K this week and over the weekend. The Planigan Shenanigans said, so ready for today. And it happened. There we go. Alexis said, are you ready for it? Cute Taylor Swift. Are you ready for it? And it's done. Tiffany Abbey said, did you see AJ in the LA District Attorney Office in Netflix docuseries Homicide LA? I feel like I lived Homicide LA, but no, I have not seen it yet. When I say I am behind on TV because of how much catching up I have been doing with this, I am behind on TV because all I have been doing is catching up on this. There is a lot going on in other cases, and I'm trying to get caught up so I can bring it to you, but it does take me time. So no, I am super behind on television. Like super behind. Super. Poema, you're going to have to tell me how to pronounce it at some point. But yes, are the charges still the same on all counts? Right now, they are all the same on still counts. I get it all the time. I just don't want to do it. But also I have no phonemic awareness. So sounding things out for my brain is incredibly difficult. And I don't want to be disrespectful. I try. So are all the charges still the same on all counts? Yes, they are for now. And that's what they are arguing over. They are arguing over whether counts 1 and counts 3 should be dismissed. And we're going to hear oral argument on that August 9th. And then we're going to hear our oral argument August 9th, and then the court will rule sometime after that. So we'll see. And thank you very much for the gifted memberships. Can we do daily bingo cards for the next trial? It depends on the trial. With the serious trials, I don't do actual bingo cards. I use it more as a colloquialism because, the trials are heavy, heavy. And the next, I don't know if we're going to get to anything before we get to another murder trial. There aren't as many civil cases that are televised. So most of the high profile cases are homicide cases. So that makes it difficult. April said, with 5 jurors speaking out, can the judge poll now? I don't think the number of jurors speaking out is how the judge is going to decide that, April. It's a really good question. I think the judge is going to decide this based on their interpretation of the law and going with the status quo. I don't think this is a judge that's inclined to do something different or to tread new ground. I think this is a judge who's very, very much going to go with the path of least resistance and go with the path of history. This court's not going to do something new. That's not going to happen. So yeah, I don't know if the judge isn't going to decide based on the number of jurors that have come forward. So Laura said, tomorrow's my 50th birthday. Happy to be honored. Well, happy early birthday. Lots here. Carrie and the cat said, I'm 40, just got accepted to law school. Just an MLS. Carrie, okay, I'm going to don't say just. Don't say just. Don't downplay your achievement and your accomplishment. There is no just. You are getting an MLS. That should be celebrated. Do not downplay it. Do not downplay it. Yay, getting an MLS. And that also is a very, very logical choice. Given that if you are second careering, it makes sense to get an MLS so that you have it and don't necessarily need to go to court. Don't downplay. Celebrate. And congratulations, we're celebrating with you. Wolf Kiara said, all we got was Wingstop. I mean, we barely even got Wingstop for that hearing. Let's see. Indigo said, love having some EDB time on a Monday. I mean, we definitely popped in for a quick court hearing. Paula, I'm going to try to grab that question. Yeah, there we go. Our chat is moving. Paula asked, is this typical behavior for a judge, appearing condescending, dismissive, rude, like a smart? It depends on the judge. Have you ever had a judge act like this in front of you or your colleagues? Yes. And what I will say is that this is not unusual behavior. And when it is male judges, it generally doesn't get commented on as much because the amount of incredibly rude male judges is very high. So is this typical judge behavior? Yes. Yes, it is. Yes, it is. So there are great judges, but there are a lot of judges who believe that the robe makes them stellar. So yeah, we do. Yeah, we do. Yeah, we do see it. And there are some that are wild, just wild. So no, it doesn't. It doesn't strike me as odd at all. This judge's behavior doesn't strike me strange at all. So, KD said, is the retrial date going to be put on hold if when they appeal? Not necessarily. They're going to have to argue for it. So we'll see. We're going to see what happens with that. It would have to be argued for, but we will see. Going to our questions tab, which is harder to pull up on screen, but trying it out nonetheless. JRN said, do you think Judge Bev should be removed from this trial? No, I don't. Because, let's see, if I don't know what happens when I do that. Do you think Judge Bev should be removed from this trial? No. This is the judge that has the history with the trial. This is the judge that has done all the rulings on the trial. This is the judge that does all of the things. So no, I don't think she should be removed from the trial. And I don't think she's going to be. And none of the lawyers at this stage have asked. They had asked in the past, but they had not asked now. So Danielle said, can you please tell them Jackson was on Zoom? I know that we did that at the beginning. So yes, Jackson was on Zoom at the beginning of this hearing and had told them he would be on Zoom when they set this date, because he also has hearings in LA. So Nightshade Winter said, I just got here. Is Jackson still on? He was fantastic. At this point, he is. We will see how that goes. So we will see how that goes. Oh, I see lots. Now I'm seeing lots of questions. Lots of questions about Jackson. Eiko Taco asked, can the defense paper the judge? For those of you that are like, Emily, what does that mean? For papering the judge, what we're talking about is whether or not they can now just do a peremptory disqualification of a judge. That ship has sailed because this is a retrial. And with a retrial, you can't just paper the judge. The judge has been assigned the case for too long. Nicholas said, where's Jackson? In Los Angeles. So they said he was appearing by Zoom. Robbie asked, can you appeal a mistrial? I mean, do you appeal a mistrial? There's nothing to appeal, really. So no, it's a mistrial. So what they are arguing with the judge on the dismissal is that the judge shouldn't have declared the mistrial when she did. So you can't appeal like the jurors not coming to a verdict. There's nothing to do about that. But if the judge didn't have to declare the mistrial when she did, is that something that will come up when they appeal later? Yes, it will absolutely come up when they appeal later. Maddie asked, will I be covering the pretrial motions? Now that we've gone through trial one, yes, we will be. Yes, we will be covering all of the pretrial motions as we go forward in this case. We went into trial one as jurors, and now we got onto the roller coaster, and now we're still here. Like, we chose this ride. We are on this ride. So we ride. Like, here we are. Here we are. Let's see. There was, oh, where did it go? Now the questions are jumping, and they're getting harder to parse than the chat. So Kim asked, can the defense ask for a change, or why didn't the defense ask for a change in venue? Like, today wasn't the right time for that, but if they want to do that, they will do that down the road. So that can happen down the road. Lyndon, good to see you in the chat, said we signed up for this. Yeah, we absolutely did sign up for this. We're here now, and we will be zooming back into our other cases. Girardi's getting ready to go to trial, and so we've got quite a lot happening. Let's see. Adela said on the 27th of January will be a blizzard. They will talk about snow once again. This is also a very fair point. Weather is going to become a factor if they do this trial in the middle of winter, isn't it? Absolutely will. Absolutely will. So let us keep going as we get through this. Let's see. I want to pull this question up. Nikita said, where is it? Oh, no, this was learning every day. Nikita's question is next. Can Karen Reed get a job while she waits on the trial date? I don't know if she lost her job when this all went down, so she can still work. She is out of custody on bond with conditions. Those conditions would not require her not to work. It's not the type of case where that would be appropriate. So she can. I don't know if her job status changed. I didn't really look into it to try to determine it. So let's see. Nikita said, does this mean the judge will not dismiss the charges 1 and 3 appeal? No, not necessarily. I think the judge is saying, I acknowledge that whatever I do, it will probably be appealed. So we're going to make sure there's time for that. But it would be unusual for the judge to dismiss those charges. It is, when I say every time I cover this, that the defense is not in the easiest position legally, it is because the defense is in an incredibly difficult position legally. Life of Cool Kid said, what is next for Karen Reed? Well, what is next? She has a hearing on August 9th, and then she waits to start trial again and tries to figure out what she's going to do in that time, and tries to figure out how she's going to pay for this to happen again, because I'm sure she spent a tremendous amount of money, and she's going to have to do that again. So yes, she can work during that time. I don't know if that's the easiest thing to do while you're pending charges like this. Witness asked in the chat, do you think Girardi will be televised? I know that Girardi will in fact not be televised. The Girardi trial is federal court, so it will not be televised. Whether or not I go for some of the trial, we have not discussed yet, but I'll ask in the member spaces. I don't know if anyone's really that interested in the Girardi case that it is worth sitting in court and giving you reporting from court every day. I imagine like People Magazine and some of those outlets will be in court. I don't know if it is more helpful for me to be in court and give reporting like that, or if it is more helpful for us to keep following along on the cases we're following along on. Here's the truth about Girardi. It's nothing new. Like, it's not going to be anything new. This trial is going to be all the ground we've already tread. It is the theft of clients and we've already tread all that ground because it's been litigated in the bankruptcy. So I don't really expect much new to come out of this. It's all already come out in the bankruptcy. Our case said, wonder if we'll get audio. No, we won't. We won't get anything about Girardi. So I'll be asking what you guys think, but there are so many other things. There are so many other things going on in law, and we've got The end of August is the Corey Richins 3-day preliminary hearing. We're going to cover that gavel to gavel. I'm really interested in what happens there. We've got some other cases we need to jump into, but again, with Girardi, it's going to be same that we've already covered. So it's probably going to take maybe a week. So Jenny said, my dogs bark at the door every time I get a Law Nerd app notification also. Oh boy. Well, we're going to have to keep that on point. Taylor said, wow, January 27th, Karen Reed trial round 2. I wouldn't block out your calendars yet. I think we will probably see, we'd probably see it change. Music to My Soul said, I'd pay to have the app alert be bring the jury. I wonder if we could make an option. Team Baker, let's make a note. Do we have options? Are these options that we have? Like what? We're working on making sure the notifications don't break everything, but I'm happy to explore the options. Sarah gifted 5 memberships. Thank you. Mila gifted 5 memberships. Thank you. And Sarah's 40th birthday is tomorrow. Happy 40th, Sarah. Streets Behind said, is there any precedent for this? I'm not sure which part we're talking about, so I'm going to guess at it and see if we get close. How about that? That works for me. We'll see what we can do. All right. Is there any precedent for this? Mistrials? Yeah, mistrials aren't super uncommon. Mistrials happen. Jurors can't come to decisions. Mistrials happen. So yeah, generally what happens when there's a mistrial is you do it again and you just go to trial again. And it generally doesn't change much. The witnesses don't change. The order of evidence doesn't change. I think this one will change. I think the court, if this goes to retrial, I think the court will pare down the witness list and be like, what we're not going to do, you're not calling the Kolakithases. I thought they were great. But if I'm the court, I'm not letting you call the Kolakithases again to say, or not both of them, to say that it was snowing and they sat at high top tables. Are you joking me? Sorry, we're doing hand lotion. Are you joking me? Like we're not doing that again. We're not going to ask 9,000 people if they were at a high top table, if they were at the basketball game, if it was snowing. We're going to use a couple witnesses to establish those facts. And that is it. We are not doing that. So the court can definitely tailor down the witness list. And we actually saw this in the hearing when we were doing a tech test last night. We were starting to watch some of the hearing in the Young Thug case. And the judge is like, no, what you're going to do, y'all are going to give me your witness list and we're going to start paring these witnesses down and moving this case along. The judge can cut off cumulative evidence even if the defense doesn't ask. So they can. They absolutely can. Let's see. Lucian Reyes asked in the questions tab, what happens if there's another mistrial? What would happen then? Then they would retry it again. Or they would have to decide if they would retry it again. The prosecution, here are the options. If it goes to trial again, and we're way out in the grounds of speculation. If it goes to trial again, and if the jury cannot come to an agreement again, then they can try it again. That's what they can do. And you guys, I'm not going to be able to use, just a note, I'm not going to be able to use the questions tab if everybody puts non-questions in there. It makes it really hard to see. I put the questions tab up so that we could pull questions more quickly from the chat so chat could chat. But if it's full of comments, then it will be harder to pull the questions. So thank you. So if there's another mistrial, what happens then? The prosecution can dismiss. The prosecution can offer a plea deal. The prosecution can choose to retry it. That's what happens. So those are the things. And some jurisdictions will have a procedure for how many they can do, but you can keep retrying a case and you can retry a case multiple times. So you can absolutely do that. So let's see what else. Caliente. Sorry, that took me a minute because it took me a minute. Today's my birthday. Happy B-Day to the rest of the July babies. Happy birthday. Jen K said, prayers for jury duty tomorrow. Silver jeans in the store. Silver jeans in store? I don't know what we mean about silver jeans, but yay. And also have fun on jury duty. Anthony, question, have you been getting my membership chat and super chat? I see them. Just had some questions wondering if proctor suspension can be brought up next trial. Anthony, I do see them. Can proctor suspension be brought up next trial? It really depends what happened. If proctor gets fired, it's going to be easier, but we've got a long way to go. Some of those things can come up because it goes to potential bias. It goes to potential bad behavior, and they can ask, hey, didn't you do this, this, and that? So that can happen. Let's see. Abby said, thank you for the coverage. Love being a law nerd. You're welcome. Laura said, if it's just oral argument, does that mean no jury questioning? Laura, yes, that's exactly what that means. However, if it's just oral argument, that means the court hasn't decided the motion. There will be multiple steps to this. Remember in Murdaugh, there were multiple steps to this. In Murdaugh, we had to go through a hearing and motions to determine whether jurors will be brought in. There are parts of this. So it will need to go to hearing, oral argument on the motions, to decide what happens next. And the defense is arguing that it should be dismissed and or the jurors should be polled, and maybe the jurors should just do affidavits. So all of those things are going to need to happen first to decide truly. So that's what's going to happen with that. So I'm going to put up a poll real quick, which means I think I need to end the Q&A. So oh no, wait, that removes all the questions from the question. Oh, darn it. I messed up. I chose badly. I'm sorry, chat. That's the first time I've used that feature in not a members only. And when I went to go switch it to a poll, I didn't realize it would delete everything. Boo. That was user error. I apologize. And thank you. We'll get to some more questions. Shall wait, no, shall means must. Do you want to rewatch the hearing? Let me ask if you guys want to rewatch the hearing. Since it was so brief, I'm going to just start a poll and we'll go yes, no on that because you must pick. You must decide. You must decide, but I did not choose wisely on that. Darn it. Oh, we're learning. Bridget said, what happens if they find Brady material now? I mean, hearings would happen, but I would need to look at the standard in Massachusetts. A lot of jurisdictions, you have to prove prejudice, and it would take a little effort to do that, but it doesn't mean it can't happen. So it's really hard to, without knowing what the thing is, to answer the thing. We would need to know exactly what the thing is to answer that. Joanne said, my bestie Kristina and I are loving you from the UK. Well, good to see you guys. So let's see. So I meant maybe jury duty tomorrow. Very nice. Don't forget Tati's trial is in August. Again, I don't think it will be televised. I would like the G bra sound bite as an alert. I don't know if we can give multiple options. How hard will it be to find a jury now? Angela, you asked this question and there were a bunch of versions of this question. Versions of that question include, how will they find a jury? Will they change venue? What does that look like? Yes, it will be hard to find a jury. Yes, it will. But that is one of the considerations when you look at a change of venue. That's what they're arguing in the Koberger motion, right? So one of the change of venue criteria is how hard it may be to find a jury. So that will come up if the defense tries to do this. And we'll see. Sherry asked again, is Alan Jackson still the lawyer since he didn't get consulted on trial dates? He was via Zoom and there's nothing that shows that he has removed from the case. There would be filings on that. So Jess, good to see you, Jess Matz. Thanks for body doubling while I prep dinner. Good for you. Yay. Let's see. Zachary, will you be able to cover the Delphi murder case? I don't know if I'm going to be covering Delphi. I have not decided yet. I very, 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 very strongly stay away from cases that have child victims. I wouldn't be doing it live, but we will see. There are some legally significant things that have happened in that case with regard to defense attorneys and rights to defense attorneys and things that I very much want to cover. So there are some legal things that need to happen, but we won't be doing day-to-day coverage, but there are some legal things that need to be covered. This is Courtney said, what does change of venue mean? Moving it to a different jurisdiction, moving it further away so you can grab more information, and that you can, not more information, hold on. Let's do that so you can grab more. Today got spammy, that's weird. Change of venue allows you to move it to a different jurisdiction so you can broaden the jury pool to hopefully get away from the intense local interest. Sometimes that doesn't help. If there is so much intense local interest, then where do you go? We will talk about change of venue a lot when we get into the Koberger hearings in August. We've got a lot of hearing dates coming up on stuff. So when we get to the Koberger stuff, we will be talking about that a lot more. Does it have to be within the same county? No, because oftentimes, Brianna, it can't be in the same county. So it's a great question. No, it doesn't have to be within the same county. It does have to be within the same state. And that's what we're seeing in Koberger as well. So thank you, Miguelina. We'll go do that in just a second. So I'm going to keep questions on this case. I'm not going to talk about other cases because, again, I've got to go back through and schedule out the docket. So I don't want to say yes or no to things because I need to go look at dates because a lot of things have shifted in the 9 weeks, 10 weeks that we've been in trial. So until my docket is updated, I cannot let you know what we are going to be doing until that docket is updated. Also, it's not just me, law nerds. Remember, when we do all of this, it is me plus the mods plus the team, and going into trial is quite a lot. Okay, this is a great question. What if someone can't afford a retrial? What are their options? Well, in criminal court, you always have the option of the public defender. So there is always the option that you don't have private counsel for the retrial. So that is an option. Let's see. I'm going to take a look at this poll. Oh, this one's close. Let's see. Oh, there's over 10,000 of you in the chat. I'm going to give it a few minutes for voting because it is really close. Right now, we're at 52% to rewatch. So if you feel strongly about rewatching, you absolutely need to go vote because there is a lot. All right. And let's get to a few more questions and we will get there. Let's see. Kelly said, thank you for being neurospicy family doubling with us. I'm so glad my latest special interest is accountability now and that I have found you. Accountability is always helpful when you have someone to body double the work day. Laura, if it's just oral arguments, does that mean no jury questioning? It means they haven't decided yet and that will be decided. So, Mila, we had gotten to happy birthday to all the July babies, including Sarah, whose 30th birthday is on Friday. Lots and lots of birthday in the chats. Yolanda said, do you think the FBI will share findings with the defense team from their investigation? I don't know if their investigation is into the police department, if it's into the DA's office and law enforcement, if it's into all of it, I don't know. So I'm not going to narrow down what the FBI investigation's in or looking at. I don't know. Do I think they will share whatever their results are? Yes, if they come to results because they have shared some of it before. Do I think that will only be with the defense? No, I don't. Joe said Glanville should preside over it. He's very fair. Glanville would just throw everybody in contempt and they would all be in custody together. The entire courtroom would just walk out of lockup together. Glanville seems to do that a lot. So will Lally put on the exact same case 2 times? LD, I think the judge will narrow it down. I really do. I don't think he'll be allowed to. Hannah said, EDB, I thought only the defense could appeal. There are circumstances where that's true. There are circumstances where the prosecution can appeal rulings. So if the court orders that the jurors do certain things and the prosecution thinks that is contrary to the law, they can appeal rulings. If someone's acquitted the prosecution can't appeal. There's nothing they can do there because it's an acquittal. But we are in the we are in the room where there's room for rulings that the prosecution could choose to appeal. And there are rulings that the prosecution can appeal. So do they always? No. Oftentimes it isn't something worth appealing for them, but I could see a circumstance where the prosecution could appeal, depending on what the judge rules here. Cooley Cullen said, 53rd birthday tomorrow. Hi from Sweden. Hi to you and happy early birthday. Lizzie asked, question, if you were the prosecution for the next trial, what would you do differently? Not. I don't know how you go forward with this case. I would need to know, here's what I would need to know to decide. I would need a lot more information from the federal witnesses, and I would need experts that could rebut the federal witnesses on the assumption that they are going to retry no matter what. They need to deal with the experts. They need to deal with the experts better. They need a better accident expert. And I would focus on that. Or I would dismiss counts 1 and 3 and just go after count 2 because the jury was already there. And then you just argue, you know what? Karen Reed caused the chain of events by getting in a fight with John O'Keefe and leaving him outside in the cold, not knowing how he was. And she left him out there. She backed her car up and caused him to do this or that. And that's what it was. Because the jury seemed to be much more inclined towards count 2 than the others. But other than not, if not's not an option, they need a better accident reconstructionist, and they have to deal with that before the next case. Do I think that they will? I don't know what they will do. Yannetti said after court the team has not changed. Yeah, I don't think they have at all. We would see filings. Like, you don't just leave a case, you would see filings. Hedgehog in Space says, who does the half-year delay help more? I mean, it just gives room for the defense to keep fighting. And I think if the defense can get 2 counts dismissed, obviously it takes the homicide off the table, which is a huge win for Karen Reed. But honestly, I think getting rid of counts 1 and 3 would also help the Commonwealth and make their case make more sense. The charges as they are now look like overreaching to me. When you look at all the evidence that comes in, it looks like overreaching. And if it is overreaching, I think it makes the jury less inclined to just rule in their favor or find her guilty. It goes to the defense theory when the prosecution overreaches in their charging in the trial that we just saw. So if the prosecution acted restrained, then what would that case look like? Can the defense make that argument the same way if the prosecution acts reasonably? So, how do you feel about a bench trial with Judge Bev? I don't think the defense would want to do that at all. This is a good case for a jury. And both sides have the right to pick. And I think both sides very much want a jury. So no, I don't think that's realistic, probable, or even a good idea, honestly. Let's see. Question, if there's a change of venue, do you keep the same judge? Generally, yes. But jurisdictions can have different rules on that, but generally, yes. Especially like yes, plus on a retrial. You generally do not want a new judge coming in. It doesn't help either side. Do you think the federal investigation will be done by January? Lindsay Tort, I have no idea what they're doing. So it's been ongoing. I have no idea what they're doing. No idea what they're doing. Avid Reader said, any chance that we can get a lighter food court sometime soonish? Yes, I need these other cases to slow down. I need the things that are going to blow up my DMs with girl, what is this, to slow down so that we can do some of our lighter topics. Cause yeah, I need it too. I absolutely do. How do you let the 4-person sign an incomplete jury sheet? The judge doesn't look. I've never seen this happen. I don't think that happened here, Ashley. I don't think they filled out anything on the jury sheets, and I don't think they signed them. And I don't think the judge recovered the jury sheets and looked. So we'll see. If Proctor gets fired before January, how much would that change the case for each side? And if Proctor gets fired, it allows the defense to question him about getting fired because of this. And I don't know, it really depends on It really depends on how they play it. It could help the prosecution to say, see, this behavior is unacceptable. And in fact, you've been fired for it, correct? Yes. But it didn't impact the rest of the investigation, correct? It allows the jury to be like, oh, this has been handled. We don't have to look more deeply. So both sides can argue it, I think, well. What if any, said Koberger and Reed at the same time? I hope not. Madam H says, so what is next with the Young Thug case? They got a new lawyer, and it looks like the jury is set to come back at the beginning of August. Noelle said, the bestest of birthday wishes to my favorite Lawner, my bestie, and my favorite outrage partner at Kimberly K. I love you well, Kimberly K. Happy birthday from your bestie, Noelle. Rune said at some point, I would love to hear your view on the AG being able to force an immunity agreement on a witness. Seems like it violates the right to free association. It is a strange thing, the forced immunity. I don't know why you would want to force immunity. I mean, I can see how it benefits prosecutors, but the witnesses, especially if it's forced immunity, not an immunity deal they wanted, the witnesses still don't tend to testify in a way that a jury is like, oh yeah, that makes sense. The testimony still can come across untruthful. So it's a strong-armed tactic, and I think there's a lot of ways that it can go wrong. Casey Cat, thank you for the gifted memberships. So agreed upon immunity, a whole different situation, and even that doesn't always go well. There's a lot of times when you give somebody immunity and they still get up there and are like lying through their teeth, and the jury's like, I didn't believe them for anything. So immunity is a mixed bag depending on the circumstance. SC Girl said, EDB, what do you know about the new attorney? I don't know anything about the new attorney. I don't always look too much into attorneys early on. I don't know if there's anything we need to know. So Music to My Soul said, why did the defense add an attorney to their team? Is it for arguing the motion to dismiss? It might well be for the motion work because they needed help. Casey Cat said, why is the Commonwealth insisting on not waiting for the feds to be done with their investigation? I don't think the Fed investigation helps them at all. So I think they want to get done with what they're doing. Let's see. Brandon Perry asked, so after a mistrial, is Karen Reed still in jail or free? Neither. Her status stays the same as it was before trial, and that was out on bond. So if she had been in custody, she would stay in custody. If she were out on recognizance, not on bond, she would stay out that way. But she's out on bond. So it stays unchanged. And they did not ask for it to change. That is a gorgeous tattoo. Wen said, were the lesser included charges 3 and 4 of count 2? Count 2 had multiple options, and all of them were lesser included except for the main charge. So they're not really counts. They're not really charges of count 2 because count 2 has just options. So it's more like A, B, C, or D, like pick one. So with Karen Reed, there are 3 charges, and count 2 has options, A, B, C, or D, if that helps to think of it that way. So yes, count 2 was the only one that had options, and those options were by operation of law. The lesser included means like if you are guilty of the most serious, all these other things also happened, and then you can go down, kind of down the line of seriousness, and the behaviors all accounted for in the dominant charge, but then to the subparts, it's less serious. So you can go. Amy's positive pathways. Commonwealth has to use the same theory, 24 miles in reverse. There's some things they can change, but it opens all of their witnesses up to cross-examination, right? Because their expert doubled down on that. And it opens up to, but in previous testimony, you said this. Are you changing your mind now? So it adds that element to it, and it makes it hard. Robbie said, question, does Karen Reed get her money back from the bond if she's found innocent? I have not worked in bail bonds. She would be acquitted, not really found innocent. I don't think they're going to do like a factual finding of innocence is a whole different court process. But if she's acquitted, then her bond would be released. I don't know what different bail bond companies set up with what amount you get back or not, but it would be released, and then that would be between her and the bail bond company. Just Call Me Hen asked, can you remind us of all the charges? Yeah, count 1 was a intentional second-degree vehicular homicide. Count 2 was the driving under the influence or operating while intoxicated, causing death. Count 3 was the hit and run, like leaving the scene, causing death. So, Yannetti went back to court to ask that Karen's bond to be released and have her released to OR. I don't know what happened with that. I know he asked, but I don't think she did. So I don't know. Question, didn't get to this the other evening, but why would the jurors not reach out to both defense and Commonwealth? We reached a verdict on 1 and 3. Why only the defense? Mags, if they don't like the way the Commonwealth did things, that might be who they feel more comfortable with. But this is speculation, purely speculation on this. When you are looking at a not guilty, I think they would want the defense to know because they want Karen Reed to know, right? Because the Commonwealth wanted them to find her guilty on everything. So I think you reach out to the side that you see kind of aligned with your position. So, hey, we need you to know that as to your client, we thought that she should be acquitted, and we need you to know that because we know you'll do something with that information as opposed to going to the prosecution. Because if you go to the prosecution, it's like, we need you to know your case sucked. I mean, I would imagine maybe sometimes jurors would do that too if they're offended by a case and say, what are you doing? But I think that they needed to tell the defense so that the client would know. That's why I think they would go directly to the defense with that information. So, and I saw AR in the chat say, if I was on the jury, I'd rather talk to AJ than Lally. So it's, you know, it probably just logically makes sense, right? Hey, I thought we acquitted her. You should know that, you're her attorney. Rachel asked a question that a lot of you ask, and we're gonna go, if we need to go over it every stream, we're gonna go over this every stream. How does double jeopardy play into this now that we know the jury was unanimous on 2 counts? That is the basis of the defense motion. I don't think we know that the jury was unanimous on 2 counts. The defense has said the jury was unanimous on 2 counts. That has yet to be proven. Those aren't affidavits. Right now, all of the statements by the jurors are technically hearsay because they are told to Jackson. Jackson represented them to the court saying, as a officer of the court, I'm representing, this is what I was told. But there's no direct evidence of that just yet. I don't have reason to disbelieve what multiple jurors have come forth and said. But in oral argument, they're going to have to talk about whether that information is going to be solidified in some way, whether it's by affidavit or testimony. That information has to be taken directly. And given that the juror who came forward in the affidavit saying they felt threatened was silent as to it, I do have some questions because that juror said nothing in their affidavit. Now, that could be because they'd already spoken to Jackson. That could be for a wide variety of reasons, but they didn't say anything in that affidavit. And with that affidavit that a juror felt threatened and is concerned for their safety, the judge is going to be, I think, even more reluctant to take any kind of affidavits or anything from the jurors. So we'll see. But that's what the defense is arguing. The defense is arguing that Karen Reed cannot be retried because of jeopardy. The prosecution is saying, no, there's no formal verdict and there's nothing that can be done. Should the prosecution perhaps dismiss count 1 and 2 if all the jurors come forward and say that? Yeah, they should. Will they do that? I don't think they will. I don't think they will. Emma said, question, if the jurors did also contact Lally, would they have to disclose that? Or could he just keep quiet to retry? No, I think he would have to disclose that. So I would have to disclose that. Great Kate said, that's hyperbole, Emily. There was no risk of violence. I didn't say there was a risk of violence. The jurors feel like there is. And if the jurors are thinking that, it is a problem. The jurors are concerned. And I don't know, with everything I've seen in this case, I understand why the juror feels that way. I really do. Vitriolic language can very, very quickly turn to in real life confrontations when you live in a community that's when you live in a community that is divided by this case. We have seen physical confrontations in this case. I'm not surprised that jurors are concerned. I'm really not. So even though they have not been directly threatened, they feel threatened. And I feel for them. I really do feel for the jurors. And it's why I ranted about it last week. So I ranted about it last week. Let's see. Glenn said, do you realize a juror spoke to a reporter? No. And it was reported this morning before you came on the air. Apparently it's to one of the Canton or Boston TV stations. I didn't know that, but we can take a look. We're going to re-air some of this real quick. So we've got 57% saying yes with 7,000 votes. So we're going to rewatch this hearing in just a minute. So let's see. CBS News. I'll take a look in just a minute. Question, if people call the prosecution's office and say, we the people don't want this, would they take that into account? I don't know this prosecutor's office well enough to know. But if it is done with grace, it is going to go further than if it is done with vitriol. And that is all I will say about that. Look, I have worked in offices where where the will of the public has been heard and where the will of the public has been discounted. So I have seen both, because sometimes the public is like, we're not doing this. And we're like, this has to be prosecuted because it is blatant or what have you. Sometimes there are popular defendants who you still prosecute even though they're popular. And sometimes there are unpopular defendants who you don't prosecute because the law's not there. You have to consider that as well, because we try to stave off people being prosecuted because they're unpopular or people not being prosecuted because they are popular. But I think the prosecution's office should also listen when you are looking at a retrial and a substantial amount of taxpayer funds and the evidence is in. I think it is much more persuasive when there's already been a trial. I think it is not as well taken before a prosecution. I think it can be very well taken after a prosecution because y'all have seen the evidence, right? So there's room to argue, look, we've seen the evidence. So there's room to say we've seen the evidence. And that's hard. So I don't know. I don't know how a prosecutor's office looks at what's happened and goes, yeah, this is cool. But I'm not there. So it's just my opinion. I'm not in that office. I don't know what they've decided. I don't know what else they know. What do you know that we don't know? Is it something? Is it nothing? I don't know. So it's a hard one. I don't like this case in that I don't know if when they go, I feel like a lot of this is overreaching and they had that evidence in their hands and could have decided to do something differently. I've said that repeatedly. Does that have any bearing on what Karen Reed did or didn't do? Not really. My feelings about this case have everything to do with the prosecution and law enforcement and what they did or didn't do. Same with Baldwin. The Baldwin case and the dismissal of the Baldwin case doesn't really speak to what Baldwin did or didn't do. It speaks to what the prosecution and law enforcement did or didn't do in their pursuit of Baldwin. You cannot violate the rules and the Constitution just because you want to prosecute somebody. That doesn't work. That doesn't work. There was a comment in the chat that said I was getting too lost in the weeds, not in the chat here, in the comment section, that said I was getting too lost in the weeds about the Baldwin stuff because I was a lawyer, and that kind of any means necessary should be taken to go after those that killed Helena Hutchins. And I'm like, if by getting lost in the weeds, you mean getting lost in like the constitutional rules to prevent government overreaching, then yeah, maybe I am lost in the weeds on that, because when you know the history of how our system came to be, it's very much reactive to, you can't just prosecute someone because you want to. And you can't just keep trying cases until you get somebody on something because you want to. With the power of the government, all things could be possible. We don't want that system. We picked a system to go a different direction than that, so you don't get back to not prosecutions, but persecutions. And that can be hard sometimes when you look at someone and you're like, you did the thing. But you can't violate the Constitution to prove somebody did the thing. And if the evidence isn't there, then the you did the thing doesn't matter. What matters is if it can be proven that somebody did the thing. There's a lot of people. There's a lot of people that do the thing and don't ever get prosecuted for doing that thing. Look at Tom fucking Girardi. Tom Girardi was stealing from clients for what? 40 years? There were over 200 reports to the state bar, and no one did a fucking thing. He did the thing. He's getting prosecuted now. 40 years he did the thing. And nothing. Frustrating. It's frustrating. And sometimes it can be really frustrating when you look at the people who have been harmed and you're like, there needs to be justice for them. It's hard when you look at the harm versus the constitutional rights. Our system puts the constitutional rights first. That's what gets put first. So that is the system that we are in, and that is a system we have chosen. And I don't know if there's a better way to do that, because you can't just overreach All right, we need to get back to questions before I continue to soliloquy. Madison asked if I will go over the FBI investigations. When we have a moment, we will go over what we know. Weingarten added as AJ and Yannetti are affiants. No, they're going to have to bring those jurors in if they're going to use them as evidence. And gosh, I don't know if we need another Weingarten trial. The writing got real spicy, though. Can you imagine? I think with their style, Rosengart would be more of AJ's style. I don't know what Yannetti would feel about that, though. Music to My Soul said, would there be anything in the pretrial motions that might explain why they went back to 5? There might be. I don't know if there are, but there might be. So let's see. Ash Knights question, will you cover Logan Paul versus CoffeeZilla? I really want to cover it now. I just haven't had time. I'm very interested. You guys know how much I love YouTuber litigation. We just have not had time. Catherine said, can they admit more testimony expertise from Dr. R? They can do a lot in a retrial. It will depend. Jen, good to see you. Ice Ice Baby said, does the Commonwealth go balls to the wall on count 2 and not focus as much on 1 and 3? I think they should maybe dismiss them. As for me, just baking cookies on the sidewalk in Las Vegas. I'm sorry, it's so warm. Let's see. With the new trial date, would that run into Kohberger's if it's kept? I don't know. I would need to map it out. Probably not, because Kohberger is supposed to be summer. So Fancy RPG said, Wise, Proctor, etc., not a Brady violation. I mean, the name calling and stuff, that all got turned over. There's nothing that's, I haven't seen anything that's not been turned over. The only thing that might need to come up is the video from the Sally Port. There might need to be more motions on that. John asked, would you represent Sarah Boone? No, I'm not A, defense attorney, B, a Florida attorney, C, it seems by the amount of attorneys that have left that perhaps she is not a cooperative client, and my threshold for people not listening to my advice when I am working is not terribly high. It's why I liked consulting very much. When I consult, it's like, here is how I see it. Do what you will. Good luck. I am not responsible. You take my advice or don't, but I am not responsible. When you are doing criminal trial, that is a whole different thing. So no. Let's see. Just Call Me Hen said, I've been watching ADB since she mentioned the Depp versus News Group. I don't remember when that was. Oh, way back with the appeal. Yes. No, way back with the UK case. Thank you. And I've been lucky to have been gifted 1 year's membership. So you guys are awesome. Look, YouTube really does prioritize memberships based on the interactivity in the chat. We need to go back. We're at 58%. We need to go back and rewatch that hearing. We'll rewatch it, and then we will take a minute to go look at some of the information that came out from this morning, and then we're going to wrap up so that we have time to do all the things we need to do so we can be here tomorrow. Because I think you guys would prefer a shorter stream today and also a stream tomorrow instead of a longer stream today. I think that's probably the preference of the chat. So I think that's probably the preference of the mods as well. It might be the preference of me as well. Me, I can't stream for 4 hours. Me, streams for 6 hours. Me, I can't stream for 3 days in a row. Me, streams for 3 days in a row. Me, I need to record the podcast. Also, me records it at 2 a.m. No, my brain works best on sleep. ADHD superpower, sleep. I need sleep. So we are going to go to court. Oh, wait, I did that wrong. All right. We're going to go to court, and we might need to modify the time of stream tomorrow. So you guys make sure you have the app so that we can get stuff done tomorrow as well, because we weren't planning on streaming, and then today was short. So let's go to court. 5 minutes. I've got the volume gained up as much as I can, so hopefully it'll balance nicely. And let's do this again. For all of you that missed it the first time, here we go. And for all of you that didn't miss it the first time, here we go again, because blink and you miss it.
Good afternoon, Mr. McLaughlin.
Good afternoon, Your Honor. Martin Weinberg, appearing on behalf of Karen Reed.
Good afternoon, Mr. Weinberg. It's nice to see you.
Good afternoon, Your Honor. David Unetti for Karen Reed.
Good afternoon, Mr. Unetti. Good afternoon, Ms. Reed. All right, so the case is scheduled.
Do you think Lally's mad no one said good morning to him? Even though it's 2 o'clock, so technically afternoon.
Today for trial assignment, and what I'd like to do is to get 3 dates. I'm aware that a motion to dismiss has been filed. I'd like to get a quick date on that, and I'm glad you're here, Mr. Weinberg, because I'd like it to be with your schedule.
So, Mr. Weinberg did file some of the stuff in the new motion. So the court said particularly, I'm glad you're here. I want to make sure it fits into your schedule for oral argument for the new motion.
We need a trial date, and we need a final trial conference. So I was thinking on the motion to dismiss, can we do it a week from Friday? It would be for oral argument only.
From the defendant's perspective, yes, Your Honor.
All right, I think that's August 2nd.
I
Mr.
apologize,
Clerk.
Kristina.
I'm going to be out of state. I return on August 3rd.
Okay. August 9th? Are you available? 2 o'clock. Are you available, Mr. Weinberg, on August 9th? Mr. Lally, is the Commonwealth available on August 9th?
Yes, Your Honor.
All right, so that's for oral argument only, okay?
2 p.m.
2 p.m.
August 9th for argument on the motion.
All right, so given the schedule, and I assume whatever I end up doing on the motion to dismiss will be appealed, in an effort to make sure we have plenty of time, I would like to schedule the jury trial on January 27th. Is the Commonwealth available?
That's fine, Your Honor.
Lally's like, yep, whatever.
That should be fine.
Okay, so January 27th for trial. And let's do the final trial conference the week of the 13th or even the week of the 6th.
Yes, there is a new defense attorney for Karen Reed for this motion. He didn't replace anybody. He was added to the team for the motion.
Just not the 9th or the 16th, but all the days are open.
Your Honor, the only caveat, I don't have anything on the 27th. I'm clear for that day, but for the fact that I have a Superior Court trial scheduled to begin in Essex County on January 13th. There are multiple...
How long do you expect it to take?
That's what I was getting to. That could take longer than 2 weeks. I'm happy to have this case take priority over that, but that's...
No, we'll hold it for you day to day if need be, and I can contact the Essex Superior Court judge once you know who he or she is.
Yeah, that's not ideal. You know, in terms of preparing for trial, I can't do a 2 or 3 week Superior Court trial and then jump into this case. I can't do that.
Okay? So what are you telling me? You just said you're willing to make this a priority, so we'll stick with the 27th?
That's what he said.
Well, okay. Well, why don't we do this? Let's put it on for the 27th. Let me see if I can make peace in Essex County. And then on the next date, when we come back for oral argument, if I can readdress the court on that issue.
Okay, I'm happy to talk to Judge McCarthy, who's the garage up there, about this.
It's yeah, okay, that's great.
All right, so let's set it for the 27th. And why don't we do the 14th for final trial conference?
At the 14th at 9 or 2?
2. If it turns out that we have, you know, in excess of 35 or whatever motions in limine still at that point, let us know and we will try and get the whole day. Okay? All right. Thank you very much.
Thank you, Your Honor.
All eyes to the floor, please.
8, 9, and 2 p.m.
And that is the end. So, Leonards, that is the scheduling conference. That is not unusual for a scheduling conference. It is, in fact, a very common length of scheduling conference. They tend to be very quick conferences, and that's all that's needed. These are the days. This is the date. That is it. Mel said, why is the Judge Bev happy to talk to the other judge? Because there are times that you need judges to communicate with one another over trial schedules to figure out trial priority. Anyone who has heard my story about judges threatening each other to physically fight over when a DA would be in a particular courtroom, this can go well, this can go badly. There are times where judges are fighting over attorneys saying, no, this attorney is supposed to start this case in my court. And I have seen judges, story time. I have seen judges tell an attorney they're in trial, bring in a panel of jurors, swear the panel in and dismiss them for 2 days so that attorney is technically in trial and cannot be pulled into trial in another courtroom. So judges' trial scheduling is actually incredibly complex with busy attorneys because when you get to trying to schedule trials, it's like overbooking flights because they might not all go. And so you will have multiple trials sometimes stacked on a particular day or week, and then you're going to try to figure out which trial is actually going to go and which trials can trail. Sometimes there are judges who are like, fine, counsel, if you're in trial in this courtroom, we're trailing this trial day by day until you're out. I have picked juries while a jury is deliberating. So I have done closing arguments, gone to another courtroom after jury instructions and started picking a jury because my trials were stacked so closely together. Thankfully, they were in the same courthouse, but I have literally started trials while other jurors are deliberating. It happens. It is very, very complex. One of the most difficult cases I had, we had 12 defense attorneys. So trying to pick dates for anything was not just herding cats. It was like herding cats on catnip in a yarn factory. It was an absolute mess. So trial scheduling. The reason the attorneys are in there is because they're trying to figure out what's going to happen. And when you're that far out, a lot can happen and trial dates can get pushed. But with a trial this long, you need, 2 months? He probably needs 3 months runway clear in his calendar where he's not in trial for this case. And so when you need that, yes, Kay Pauling's 12 defense attorneys plus me. It was, 12 defendants. They all had their own attorneys, but yes. When it was, that's a whole nother circumstance. It was not a RICO case. So when you have that, when you have that much need for a long trial for a runway, you need the runway to prep and then you need the runway for trial. So Yannetti probably needs, I mean, when he's looking at his calendar, 3+ months of runway around that case at least, which is really hard to navigate when you have a busy trial schedule. And a lot of trials will take 3-4 days, maybe a week. Like a lot of trials don't take this long. So I feel for the attorneys in this case and I feel for the court because the court blocking out a date for a trial like this for the judge can also fuck their calendar. So it really becomes a very difficult thing to block that much time and then shift it. Sina said, did Baldwin have that many attorneys too? It doesn't matter if they're that many attorneys for one defendant. It's when they all have different clients. They all need to be in court at the same time. Like Baldwin's lawyers, one can show up for court. So with all of that, it was a lot. We'll talk more about that case. We always talk about cases on members only. We'll talk about it another day. So Rex said you never would have gotten 12 attorneys in this courtroom. No, we had to change courtrooms for hearings on that particular case. We had to change courtrooms to another courthouse to accommodate all of the attorneys. But it was a thing. It was a large, we don't do anything simple. My brain likes complexity, so complex things tend to find my way. Let's see. Casey Cat said, thank you for the gifted memberships. I appreciate it. KK asked, how do they decide which courtroom to use? Is it based on whatever's free? I think this is the judge's standard courtroom. Because of the defense motion, they had moved courtrooms for trial. So when Plan Hoarder says so many timing issues, yeah, it's complex. Will Newman said, is there a reason they're in a different courtroom? This is, I believe, the court's normal courtroom, but there are also courts that ride circuit. When we look at Judge Newman in South Carolina, Judge Newman was out of his normal courtroom all the time. So Judge Newman would be in different jurisdictions because it was one judge and the judge would go to different courthouses. Some judges ride circuit like that. It really, really depends on the jurisdiction. I mean, in Massachusetts, the judges switch between a civil calendar and a criminal calendar. I don't know how the fuck they would do that. That would make me crazy. That would make me crazy. But you can also switch courtrooms to accommodate the audience, to accommodate the attorneys. There's a lot of reasons, but I don't know how you would switch between criminal calendar and civil calendar. Ugh. It's, oh God, it's just so different. And trying to balance those two different types of calendars would be tremendously difficult. There's times when people are like, would you ever want to be a judge? Not like that. Oh God, not like that. That would be awful. That would be so awful. Awful. So let's see. The only thing I have seen with regard to a deliberating juror is that Kristina Rex over on Twitter, who is a reporter, indicated that they spoke to a sitting juror. So let me take a look at that real quick. I don't think I can pull that up because as we switched layouts, things have gotten harder. So let me take a look at that. So Ted Daniels said, we are in a third and even smaller courtroom, but media gets jury seats because no jury's here. So that was a different courtroom entirely, not the judge's normal courtroom at all. and a third and smaller courtroom, which is interesting. Let's see. Kristina Rex said, I have spoken with a juror face to face and confirmed with my own eyes that they were on the jury. I was in the courtroom every day and saw the jurors' faces breaking. I spoke with the deliberating juror from the Karen Reed trial. This juror independently confirmed to me that the jury was unanimous for acquittal on charges 1 and 3, second-degree murder and leaving the scene. Let's see. This is coming from Twitter. The juror confirmed that the jury was hung on the lesser included charges under count 2 manslaughter. Their final vote was a soft 9-3 with 9 voting guilty. The jury considered being more specific in their notes to the judge, but were not clear on how they were supposed to communicate their unanimous decisions. 9-3 for guilt on the lesser includeds. So if I were the Commonwealth, I would take that information and I would narrow down my prosecution. Again, if forced to prosecute. But I've already told you how I felt about that. But I would take that information and use that for that reason. Let's see. This is just not pulling up smoothly on my computer because I am not logged in. So I cannot share screen. But that is what is being reported, and that is what is happening. But the jurors, remember, the judge made a ruling that the jurors would stay anonymous, but very clearly said that the jury could choose to come forward. So there you have it. The jurors must be so frustrated. They must be very, very frustrated. Let's see. Does Bev saying that there will be an appeal mean she's already decided to deny the motion to dismiss, or can the prosecution appeal? The prosecution can also appeal rulings pre-trial. So what do you mean we don't get a 4 to 6 hour stream? Yes, today is going to be, well, today we're going to start wrapping up here. Have you thought about covering the Sarah Boone trial? I have thought about it. We will see if the timing works out with other things that are on the docket. I have not heard of that case at all, Carl. So maybe. Lynn, wouldn't it be easier for the parties to wait for the IA and FBI investigations? Would it be easier? Probably. Can they do that at this point? No, they've got timing to retry. So they're on a clock that they have to adhere to. Z said, I thought the prosecution couldn't appeal. There are some things the prosecution cannot appeal, but the prosecution can appeal pretrial rulings and the court's pretrial rulings. It's unusual, but they absolutely can. They can't, if there's an acquittal, they can't appeal the judge's rulings during trial because there's been an acquittal and jeopardy attaches. But they can appeal pretrial motions. Casey Cat said the kitten everyone was helping me name ended up being called Hercule from the Agatha Christie novels, or Hercule. Sorry, currently in the cat tree in a catnip-induced haze. Well, at least not in a yarn factory. Wendy Darling said, will Judge Bev always be the judge, even if a retrial? I mean, yes, with an asterisk. I mean, something could happen, right? But at this point, yes, unless something dramatic happened, yes. Also, thank you for my Law Nerd cap. Love it. Bella the dog loves it more, and she watches you every day with me. Well, thank you. Miss Donisha, good to see you. My brain just crashed. What happened? The ADHD and brain damage said nope. The court set dates. We'll be back in August to hear motions. K Skills said, is AJ coming back? Didn't hear anyone mention his calendar. Yes, AJ is still on the case. There is no indication that he's not. So, but he's not in Massachusetts. He was on Zoom for this hearing and said that he was. But no, they didn't ask him about his schedule, but he also might have told them what his schedule was in advance anyway. He might also be assuming that they are, that they're going to be appealing, and even whatever trial date they set's not going to actually go. So you never know. Carrie said, what is the next gavel to gavel trial? I am still working on my docket to try to figure out exactly what is next, timing wise, because things keep getting shuffled. Kelly Kell said, wait, I just got here. I know that hearing was like 5 minutes and we started right at the beginning. Also, Kath said, wish me luck. Got accepted to college at 54. Congratulations, Kath. Hold on. You get applause for that. Lots of law nerds being like, let's go do the thing. And I'm excited for you. So yay. All right. There's a lot that can happen between now and then. So there's a lot that can happen between now and then. It's a lot. So I feel for this jury. I really do. I really do. I love how Emily still calls it her docket, even though she's not practicing anymore. I mean, we're practicing streaming. We're practicing streaming. And even when I get asked to do things, I'm like, can't. My trial schedule, streaming trial schedule, is full. I got asked if I could make lunch today, and I was like, I've got court. So I basically treat it as if it's my own schedule, because it's basically my own schedule at this point. I'm going to try to pull up those tweets and let's see if this will work, because it's not video. So if it's not video, this should work, because I do want to show you guys what was said. And I don't want you to have to venture into an app that is becoming more and more a Thunderdome day by day if you don't have to. Because the less you have to, the less you get sucked into all the other shit that's going on that it seems to foist upon you, whether it's wanted or not. So, Emily, tell us how you really feel. That the way I love sticking to my Lawnerd app the most. Love it, love it, love it. All right, this should work. There we go. Breaking, I just spoke with a deliberating juror from the Karen Reed trial. This juror independently confirmed to me that the jury was unanimous for acquittal on charges 1 and 3. The juror confirmed that the jury was hung on the lesser included charges under charge 2 manslaughter. Their final vote was a soft 9-3. This might not, with 9 voting guilty, this might not actually help the defense. The jury considered being more specific in their note to the judge, but were not clear on how they were supposed to communicate their unanimous decision on charges 1 and 3. It's frustrating. It's really, really frustrating. So, what do I think, and why do I think that might not help the defense? Because it might leave room for argument. It might leave room for argument from the prosecution that the jury was still negotiating and the jury had not come to a final verdict. If the jury had a soft vote at 9-3, there is still room for them to undo their other decisions, but this is why it should have been asked. I think the defense still has room to argue. I think the defense is still going to ask the court to dismiss it. I think the prosecution always has the opportunity to dismiss it, but I get it. I get why they get to count 2. Some of those lesser includeds were chain of events, and I can understand where they are. So I feel for this jury. I really do. And if you were one of the jurors that spent 9 weeks doing this, I can understand why they don't feel like it's right that they never got to tell anybody what their verdict is. And I think the interests of justice have to outweigh. And even if the judge doesn't dismiss, I will be incredibly frustrated if we don't see some movement from the prosecution. I think this will end up on appeal, but it really should be the will of the people. And if they were confused, that will shouldn't be flouted just because they were confused. Because how do you spend 9 weeks and you come to a decision, and then to hear that you thought that somebody didn't commit a murder based on all the evidence, and then because you didn't understand, that doesn't get heard, and then they get retried on it, that's very frustrating. And the defense is really leaning into that argument that the will of the people should override. And that's really what matters most. The law is not easy on that, but the prosecution always has the option to dismiss charges. Do I think that will happen? I'm not optimistic. Lindsay M said, hey, Emily, love watching you and hearing your insights. Thank you. You and the chat have kept me company in my miserable job. I'm sorry, but we're glad we're here. But I just accepted an awesome new job with a big raise. Whoop, whoop. Look, Lindsay, I'm so excited. And hopefully some of the chat will be like, it can be done. Looking forward to watching you with the replay crew. I have worked some also miserable jobs. This is more fun. Oh, there was a lifeguarding job where we also had to clean the bathrooms. Cleaning bathrooms is always spicy, or has the option to be spicy. Like cleaning my own bathrooms now that my kids are a little bit older is less spicy. I also now have help with that. But now that the kids are older, less spicy. Younger kids, more spicy. Cleaning bathrooms that are wet is a different level of spicy. Also, water can upset people's tummies in different ways. And so when I took the lifeguarding job, was I aware that that was also part of the lifeguarding job? No, I was not. But is my character different because of it? Maybe. Because I have done, when I talk about doing all the things, I have done all the things. But wet bathrooms. Wet bathrooms are spicy in their own way. I'm having visceral reactions. Campground bathrooms at Lake Michigan, man, those get gross. Dog Mom 5 said I was a lifeguard and we had to clean the bathrooms. Did not know. Cena said cleaning bathrooms in a club, it was challenging. Oh boy. Bathroom cleaning should be more than minimum wage. I mean, agreed. It's spicy. Jen said EDB starting a new job tomorrow. Thank you for keeping me company during my layoff. You're welcome. I'm here for you, and congratulations on the new job. I hate it when people would throw soggy paper balls to stick to the ceiling. Like, why do people do that? I don't understand. Never, ever, ever in my life have I been like, you know what I think sounds like a good idea? I don't know. I knew there was a reason I was never a lifeguard. Look, there were other lifeguard jobs that were better. There were other lifeguard jobs that were better, but it was a challenge. Easier at my own home. But, I am very smell sensitive. It's also why I didn't last very long working as an EMT. Smell sensitive. So, but yeah. So it's just wild. Donna said, I don't really understand how men can miss. It's something my boys and I talk about regularly. They also get to work on cleaning that up themselves. So we are now at an age where we get to learn. We get to learn through doing, and that helps. So, yeah. Outdoor public swimming pool, changing rooms with old wooden benches and open plan showers. Yeah, that's about what it is. But we've had some spicy jobs. Look, jobs are spicy. Though I think the thing is, when you've had spicy jobs, it can help you be a citizen in different ways. Everyone should work some of the spicy jobs. Look, there are definitely things that we should all experience. I think it would make us better citizens, right? All right, let us continue. Let's continue with your Q&A. We're going to start wrapping up. So just so you have a heads up, Emily keeps going. I know nobody believes me when I say I'm wrapping up, but we are. We have to. Justice for All 444 says, love your analysis. Thank you for explaining. You're welcome. I hope it alleviates some of the confusion. If the court approves the motion to dismiss, could the Commonwealth appeal? They could. They could appeal the ruling. Yep. Casey Katz, yeah, depending on what the ruling is, they could appeal it. It would depend on the way the judge does it. So, but yes, in theory. Why is the Commonwealth insistent on not waiting for the feds to be done with their investigation? Casey Cat, with the retrial, they have a window of time they have to retry it in, so they don't have that option, and they don't seem inclined to dismiss and refile. So that's where we're at. Peggy, thank you for the gifted memberships. I appreciate it. Does chain of events mean Karen left him outside? 22 SCHG, no one ever explained the chain of events jury instruction. So it could. But no one argued it. No one explained it. No one talked about it. Beldy said, will the FBI investigation findings be made public? It depends on what they do with it. So possibly. Sarah said, just welcome first grandbaby and future Leonard. Congratulations. I hope everyone is well. Whitney, said, can the chain reaction lesser included? Can you explain that more? Like she dropped him off and that's enough to be found guilty. No one explained it. So will we explore those lesser includeds more as we get deeper into this case? Yes. Are we going to do that today? No. But will we explore that more? Yes, we will. No, this jury was confused about it because they read the jury instructions. That's in the jury instructions and no one explained it. But we will, I think that'll be helpful. We will dive into it a little bit more. Maybe we'll do that on the podcast this week. Do you guys want to do that on the podcast this week? Like dive into what that looks like? Maybe we'll just do that for the podcast. What do you guys think? Let me know in the chat if that's a yes, if you want me to break that down. And we can go through, now that we know that the jury is, what, tentatively 9-3 on those lesser includeds, do we just break down the lesser includeds on the podcast? I mean, there's nothing else that's super time sensitive that can't push. I can push other things and just do that. The chat looks like they're saying yes. See, isn't it great to be here as a chat? You get to help decide. All right, that's what we're doing. Yes, yes, yes. Okay. We'll break it down for the podcast this week. Sure. Yep. Absolutely. That we can do. All right. We'll do that. So SH said, made another live, got my fax hat today and DCI this weekend. Happy Law and Order Day. DCI this weekend for me too, SH. I hope the weather holds. I don't know if the whole fam will be going to DCI this weekend. I got to talk to my youngest, who's also noise sensitive. We are such a neurospicy family. There are times my youngest will like go out to dinner. He'll walk into a restaurant. He's like, I can't. He's like, the smell in here today is a no for me, dog. And I'm like, I guess we're changing course. It is spicy, but I guess we'll do that on the podcast. Looks good. So that's what we'll do today. All right. So with all of that, y'all, chat your bay. Thank you. I appreciate you. It's good to see you. And I will see you guys soon. So all the things. Members, I will let you know when we are recording the podcast. Mods, I will let you know what time works for tomorrow. So for those of you asking what does noise sensitive means, he will get sensory overloaded depending on the type of noise. So we do headphones, but there are some times that even that does not help. And with drum and bugle corps, I love the wall of sound. Like when people are like, Emily, take noise protection to a concert, I'm just like, just hit me with all of the sound. Hit me with all of the sound. I want to feel drum percussions in my chest. I want my brain to rattle because of the noise. Though I will say this weekend at Def Leppard, I was like, this is why I have backup ear protection, because they have turned it up to 27. But particularly the drum strikes for drum and bugle corps can be, well, this is a kiddo that doesn't like fireworks either. So headphones for him, but sometimes that doesn't work. So it just depends. But I love the loud concert. Like I want to hear it, but there are lots of different ways that sensory stuff can be challenging. Noise is one of them. Light is one of them. Smells are one of them. Sensory brains. So the noise sensory, I am not sensitive to loud noises, but I am highly distractible to background noises. So even though a loud noise won't get me, somebody tapping their pen while we're taking the bar exam will make me consider crimes of all sorts of proportions. So for me, when I am in a focused environment, I need noise canceling then, because it is those background noises when I'm trying to focus in the quiet that I need it. Loud doesn't bother me at all, but quiet background noise, fuck off. I can't. And that's where I need my noise canceling. So with all of that, brains are sensitive. Look, our brains are spicy. The more we know about our brains, the more we can accommodate ourselves and let those around us know. I had a coworker who was horrendously smell sensitive to all the things. And she was like, I'm sorry, but whatever hand lotion that is makes me want to vomit all day long. I'm like, girl, we can change it. Like, I get you. And some people were not as conscientious, but I try to do it with like hand sanitizer and perfume on airplanes and stuff, because that's the worst. If you're smell sensitive and somebody is overloaded and like Dracar Noir on the plane and you're just like, Did a high school boyfriend wear your car? Yes. Was it a lot? Yes. And you're overloaded. You can't get away. So I just try to be mindful because there are sensory things you can't get around. Miss Ann, last question. Def Leppard Journey did Cheap Trick open? No. Steve Miller Band open, and it was fucking amazing. It was amazing. Steve Miller Band was amazing. I had the best time. I would have loved to have seen Cheap Trick. I was so happy to see Steve Miller. They were great. Journey was great. Def Leppard was great. I don't love the way they sound mix Def Leppard. It was muddy. Like the sound mix just wasn't as crisp. Steve Miller's sound mix, A, was super crisp. B, sounded amazing. Like, oh, so good. His voice sounded so good. 10 out of 10. Paula Abdul sounded great. She was opening for not Backstreet Boys. Jesus, Emily. New Kids on the Block. She sounded amazing. Just sounded so good. Sounded so good. Just someone I know. I bring it with me. I am trying. So I am trying. But yes, Steve Miller was fantastic. So I do have loops. I need to get some for my kid. He prefers over ear. So, but Paula, amazing. So does Emily love a summer concert season? Mm-hmm. And I loved seeing Law Nerds. It was great to see Law Nerds when people are like, Emily, tell me about the Law Nerds. I'm like, they me. Did we see Law Nerds at New Kids on the Block? Yes. Did I see Law Nerds at Journey and Def Leppard? Yes. Does that surprise me at all? No, it doesn't. It doesn't surprise me at all. Am I surprised when I run into Law Nerds when I know they're going to like the same shit I do? Never. I'm delighted by it. So to all of the Law Nerds that said hello at the concert, it was lovely to see you. It was nice to get to chat for a minute. I hope your night was as good as mine. And look, we didn't get wet. It was fantastic. I absolutely love it. Steve Miller was awesome. If Journey, Def Leppard, and Steve Miller or Cheap Trick are coming to you, go. Would I take ear protection for Def Leppard? Yeah, I fucking would. Yeah, I would. Because Def Leppard is loud. Cindy, I will say, Cindy said, can't stand crowds, so concerts are out. I would just say Dave Matthews does stream a lot of their concerts on YouTube and Sirius XM. So there might be other ways to enjoy some live music, and some other bands have their concerts up online as well. So it might be a through the screen experience. And I didn't ever think I would enjoy that as much as I did during the pandemic when Dave was doing stuff that they were just streaming from. Dave was like streaming live music from home. And it was really nice to just get together and just be like, okay, we're through the screen. So there are ways. There are definitely ways. All right. With all of that, thank you all for being here. I appreciate you. Law Nerds, thank you. It's always good to see you. We will talk tomorrow. We will see what we're covering tomorrow. Maybe we're saying, we'll see. Maybe we'll try to cover the Logan Paul stuff. Let me take a look at what's going on in a few other cases, and maybe we'll try to cover the Logan Paul stuff, and we'll break down those lesser included counts for the podcast. I got Law Nerds. I got you. Maybe we'll just dive into some YouTube specific fuckery tomorrow. Does that sound good? It feels like it's maybe a better option. So with that, thank you for being here, and I will talk to you tomorrow. Law Nerds. We're just going to do both, right? It'll be a shorter ride tomorrow, but we'll just do both.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.